I don't understand what you're saying. I don't speak your language. I only speak man to man.
We're in Green Bay, Wisconsin, where 22-year-old Ryan Desmith and 24-year-old Jordan Salmi are appearing on gun possession charges. 3 weeks earlier, the men attended a church Christmas pageant armed with loaded semi-automatic pistols. Desmith and Salmi are members of what's called the Hebrew Israelite community, along with former Green Bay Packer Kabir Baja Biamila, known as KGB. KGB was involved in a dispute with his ex-wife over his religious objections to their children appearing in the pageant. He asked the men to film the event in his absence for evidence. Desmith and Salmi refused to leave when church leaders asked. Police arrived and charged them both with disorderly conduct, obstructing an officer, and carrying a concealed weapon. Today, they're at the Brown County Court for a first appearance on the charges. And they're not going to make things easy for County Court Commissioner Cynthia Vopal.
Did you get my notice?
Your notice, sir?
I'm not a sir.
I'm gonna have a seat.
Have a seat, please.
The notice that Desmith asks about is one of a series of handwritten notes he and Salmi filed, which claim they're not part of the legal society and quote, idiots before the court. Their list of demands includes $300,000, no jail time, and various apologies and retractions. The commissioner moves on.
Do you plan on hiring an attorney?
I don't understand what you're saying. I don't speak your language. I only speak man to man.
Okay. I'm going to enter not guilty pleas on your behalf.
If you enter a plea on my behalf, you will be held fully liable.
And you will have these cases, we will be then sending this case upstairs.
Desmith's defiance and language are similar to courtroom strategies of the sovereign citizen movement, which claims that state courts hold no jurisdiction over them.
Who are you?
I am the court commissioner. I'm in charge of hearing this introductory hearing in the court.
Who are you?
She just answered the question, sir.
Sir, we don't have time for this. I have a courtroom full of people.
I'm not a sir.
The hearing ends when Desmith refuses to sign his bond paperwork.
Either sign this or we're gonna mark it as refused.
I deny service.
Okay. Refused, and then you can leave. Okay, we're done here.
Goodbye.
On his way out, he fist bumps his supporters, including KGB, who's watching from the gallery. The court has even less time for Salmi's dissent, which lasts only 30 seconds.
For I, man Jordan Salmi, am in a state of man, now passing forthwith. I'm not a
Let me
respondent
take
or
him in.
defendant.
You can leave. I'm asking you to leave.
Is that an order?
Leave, please.
5 months later, despite more disruptive court appearances, Desmith and Salmi's obstructing and disorderly charges were dismissed as part of a plea agreement. They were sentenced to 1 year probation for carrying a concealed weapon and banned from owning firearms in that time. They also had to write letters of apology to officers at the scene of the incident.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience for it.
Next, we go to Centerville, Michigan for a preliminary hearing. 66-year-old Rosalind Keenan has been charged with resisting and obstructing a police officer and driving with a suspended license. The resisting and obstructing charge, a felony, is punishable by up to 2 years in prison, while driving with a suspended license, a misdemeanor, could land her in jail for an additional 93 days. Keenan is free on $10,000 bond, and today she appears without an attorney before Judge Jeffrey Middleton to discuss next steps in the case.
Are you Rosalind Ray Keenan?
I'm here as a sui juris impropria persona, Rosalind-Ray, family of Keenan, beneficiary.
Keenan appears to be making a sovereign citizen argument by refusing to identify herself to the judge.
I'm here under fraud, menace, and duress.
Judge Middleton checks in with the state prosecutor, David Marvin.
Mr. Marvin, is there a plea offer here?
What I would do is offer an attempt resisting and obstructing and dismiss count 2. And if there's no other incidents with law enforcement or any other reason to continue, I would dismiss this.
What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
I don't understand that.
Mr. Marvin, let's just put on a plea.
Games. I'm serious.
You are playing games, and first of all,
I'm
you don't.
trying to advance to
All right,
what
stop.
I'm here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me because these charges could result in your incarceration.
May I ask what jurisdiction? Is this civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
I have to know the jurisdiction. This court is operating under.
Stop.
Sixth Amendment grants me the right to know the jurisdiction being applied.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, I find that you're in contempt. You're
I do
going
not
to jail.
I'm simply
This matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going
I
to
do
jail
not
for
wish to be
24
in
hours.
contempt.
I know you don't wish to go to jail, but you certainly
I will
earned it.
continue with this if you please let me finish.
We'll talk about it tomorrow, and you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
If you wanna
with the
continue-
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3 o'clock.
The next day, after spending a night in jail, Keenan returns to court, but with a very different demeanor.
Would you like me to appoint an attorney for you?
Yes,
All right, I'm going to appoint an attorney.
thank you.
Keenan was released from jail, and Judge Middleton scheduled a follow-up hearing. The case is pending. We head to Southfield, Michigan for a pretrial hearing. 56-year-old Michael Harris has been charged with driving with a suspended license. After spending a day in jail, he posted a $150 bond and was released.
City of Southfield versus Michael Harris.
Today, Harris appears before Judge Sheila Johnson to review his charges. He appears without an attorney and, from the start, seems to be uncooperative.
Mr. Harris, would you please come to the podium?
I challenge jurisdiction.
Mr. Harris, I need you to step to the podium.
If I step to the podium, it'll be under threat, duress, coercion.
Well, fine, just do it.
Okay, no problem. But I'm here, I'm at the podium under threat, duress, and coercion. Well, other than that, I challenge jurisdiction.
Okay.
Without prejudice, I, Mikael Eric Colin Harris, beneficiary and sovereign principal, am here under fraud, threat, duress, coercion, and extortion fiduciary, Ms. Sheila Johnson.
Harris has begun arguing in a style similar to sovereign citizens, a group who believe certain laws don't apply to them.
This is a Social Security Cessate Trust action in which you are now a real party and interest to. This is a military admiralty tribunal and maritime law. So you accept the challenge of the jurisdiction.
You can challenge it. I'm not stopping you from challenging it.
Do you accept the challenge?
I don't know what you mean by accept the challenge.
Do you accept that this is a maritime admiralty law?
No,
You don't accept that?
this has nothing to do with admiralty, sir. This is simply a charge that you're here for.
Yeah, but
It's nothing to do with the sea, vessels, or anything like that, which are boats. Admiralty law applies to that.
Yes.
This right here is a driving a car offense.
The judge tries to get back on track by explaining the severity of Harris's charges.
And it's a 93-day misdemeanor carrying up to $500 fine, and it carries a possible suspension of your driver's license, additional points to your driver's license, and possible vehicle immobilization of any vehicle that you're driving. That's what this charge is, and it's not admiralty law. You're using language that legally doesn't make sense for what we're here for.
But all this is a corporation.
Okay.
This is not a corporation. Are you saying this is not a corporation?
Sir,
I'm asking.
I have no idea what you're even talking about.
But I'm asking you a question. I mean, it is not maritime admiralty law, and
It's
also
not maritime law.
Is it
No.
The judge holds her ground, refusing to legitimize Harris's position.
I'm telling you what I know doesn't apply.
Right. I never said that, though.
Okay.
What I said is, I am a sovereign principal, and I am the beneficiary.
Well, sir.
You are fiduciary.
I'm telling you that what you are, as whoever you are, is charged with today. Now, you have certain options here. You can certainly have a trial if you want a trial on whether or not you were operating a motor vehicle without a valid license from the state of Michigan because it was suspended.
I object. I've equipped you with all the information you need to show down the sovereign principle, and also to show you in your Constitution, it says that I can travel.
Sir, if you want to file a motion, file a motion.
Okay,
because no one can respond to all of this. Whatever you're saying, he can't respond to it.
I motion that you.
You have to file it in writing and cite your authority under law.
I did that.
And if you want to do that, you can do that. Otherwise, we're going to have to set your case for trial.
Under a Power of Appointment Act of 1951, I appoint the judge, executive. I would like y'all not to breach a contract. I mean, breach of duty, breach your fiduciary duties.
Give me a jury trial date.
May 9th.
May 9th. 8:30. If you need to file a motion between now and May 9th, you better do it before the end of March.
Have a great day.
Harris has yet to officially enter a plea or file any motions. His case is pending. Next, we're in La Plata, Maryland for a jury selection. 25-year-old Delvon King is representing himself today on weapons charges after he was caught carrying a regulated firearm during a traffic stop. Just 3 months earlier, King was appearing at a preliminary hearing for the charges when he fled the courtroom and temporarily eluded police. Because of the fleeing incident, King is required to wear a remote control stun cuff on his leg while appearing in court. And now, as he reads a prepared argument, Stop. There seems to be another problem. At the bench is 72-year-old Robert Naley. The judge retired the previous year, but was called back part-time to hear cases. This hearing got off to a rocky start when King claimed to be a Moorish American, an offshoot of the anti-government sovereign citizen movement, and insisted his true name was not Delvon King. Now, as Judge Naley explains the jury selection process, King continues reading from his prepared argument, which questions the court's jurisdiction over him.
Stop. Mr. Sheriff, do it. Use it. All right, I'm going to take 5. Don't it calms down, and I'll be back. Yes, sir. 5 minutes.
In case you missed that, after King refuses to stop speaking,
Stop.
Judge Naley orders the courtroom deputy to activate the stun cuff on King's leg.
Mr. Sheriff, do it. Use it.
The deputy calmly approaches King, who doesn't appear to see him, and slides his chair out of the way. While King writhes in pain on the courtroom floor, Judge Naley decides to exit the courtroom and take a short break.
All right, I'm going to take 5. Sir. 5 minutes.
Following the brief recess, Judge Naley resumed the hearing, and King continued representing himself. He later agreed to probation before judgment, meaning in his case, he was sentenced to 2 years in jail on the weapons charge, most of which he'd already served, and in return, no actual conviction would be added to his record. The same cannot be said for Judge Robert Naley. After the courtroom video was made public, the Maryland Court of Appeals immediately rescinded Naley's ability to hear cases.
All right.
He would also later be charged with a misdemeanor civil rights violation, to which he pleaded guilty, and was sentenced to a year probation, ordered to take anger management classes, and pay a $5,000 fine. Following his sentence, Robert Naley was banned from the bench for life.
I'm dealing with the wolves. There's no fair trial in this military maritime courts.
Next, we're at a virtual arraignment hearing in Lenawee County, Michigan. 5 months earlier, defendant Robert Joseph Matson was pulled over for a traffic violation. Officers found cocaine and an open alcohol container. Matson was also charged with operating a vehicle on a suspended license.
All right, we are on the record then in the matter of the people of the state of Michigan versus Robert Joseph Matson. Sir, you are Robert Joseph Matson, correct?
I am an attorney for the all caps name Robert Joseph Matson. I am living flesh and blood, human. Upper and lowercase, Robert hyphen Joseph :space Matson.
Matson identifies as a sovereign citizen and believes certain laws don't apply to him. Public Defender James Daly was appointed standby attorney at an earlier hearing, but Matson wants to represent himself.
I never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
I was appointed as standby, Your Honor. Mr. Matson and I, we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
It is Matson's right to represent himself, but Judge Michael Olsaver must make sure he fully understands the consequences of that decision.
I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side.
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts.
Do you have any hesitation about the fact that you want to represent yourself?
No. No matter what you do to me, I will get out of it, and there will be lawsuits.
The judge moves on and ends the hearing by entering a not guilty plea on Matson's behalf, since he refuses to enter a plea on his own. Matson was already being held on $50,000 bond for failing to appear at an earlier hearing, so he remains in jail. A month later, at a pretrial conference, he's seemingly had a change of attitude.
James Daly on behalf of the defendant.
Matson ditches his do-it-yourself approach and allows Daly to represent him. And that's not all he's changed his mind about.
And it's my understanding that a plea agreement has been reached.
Yes, Your Honor. It's my understanding Mr. Matson will be pleading to count 4 attempted possession of amphetamine on the amended information that was sent to both the court and defense today.
All right, Mr. Daly, is that your understanding of the plea agreement as well?
It is, Your Honor, along with the fact that Mr. Matson would be released from custody today.
It's not part of the plea agreement, but it is something after the plea that I would have no objection to.
Matson has a lawyer, a plea deal, and he's getting out of jail until his sentencing. Plus, his bond is being reduced to a no-fee personal recognizance bond. Judge Olsaver is ready to move on to the plea deal.
Mr. Mattson, will you raise your right hand, please?
If I'm not gonna get out today, there's no deal. We got trial Friday, I'm just going to trial. I want to make sure that I'm gonna be released, so I'm not gonna take the plea today.
That's not what I said, Mr. Mattson. I did say I'm agreeing to a bond reduction today, but that is separate and not contingent on the plea.
For release. Trial Friday, that's it.
Mattson doesn't realize he's getting out. He rejects the plea deal and demands a trial instead.
So, Mr. Mattson, there is an agreement to a bond reduction today, so.
It's a PR bond, correct?
Yes.
Okay.
Now that that's cleared up, the judge proceeds, again, with Mattson's plea.
Mr. Mattson, is it your intention to plead guilty today to count 4 on the amended information, which is attempted controlled substance, but attempted possession of cocaine, heroin, or another narcotic of less than 25 grams?
Under duress, yes.
All right, I'm not going to take a plea that is on the record stated as being under.
Your Honor.
Mattson seems bent on undoing his new plea deal. Defendants must enter these agreements of their own free will, no coercion or duress. Public Defender Daly looks exhausted. Mattson reconsiders and drops his duress claim.
So you want to move forward with your plea now?
Yeah.
How do you wish to plead then to the charge that's attempted possession of cocaine, heroin, or another narcotic of less than 25 grams?
Guilty.
Finally, Mattson makes good on his plea deal and is found guilty on the lesser drug charge. He's free on bond, awaiting sentencing.
Will you produce the document that has my signature that gives you jurisdiction? Will you produce that?
We're in Concord, New Hampshire, and the man bellowing at the judge is 85-year-old State Representative Dick Marple. A year earlier, the New Hampshire lawmaker was charged with driving after having his license suspended.
Please rise. Congressman Court is now in session.
Today is the first day of trial, but this simple suspended license case might not be so simple after all.
State versus A. Marple.
You might notice Marple is not at the defense table, and that's because as a sovereign citizen, he does not believe the court, or Judge Kristen Spath, have jurisdiction over him.
We are in the right call for state.
Madam Magistrate.
Yes.
I am here under threat, duress, and coercion. I'm not here because of an order, because you as a magistrate cannot make an order. You can only administer ministerial duties. You have no jurisdiction to judge your own jurisdiction.
Judge Spath then calmly explains the legal steps Marple can take to contest her jurisdiction after the trial is complete.
You will have an absolute right to appeal my decision.
You have no decision because you don't have any jurisdiction. You come out with what's called an order. You can't make an order because you're not a judge.
Well, Mr. Marple,
You are acting in an administrative capacity.
I continue to disagree with you.
The only question to agree is the question of the law. You either obey the law or you are in violation of your oath of office.
After taking a couple of personal shots on the chin, Judge Spath once again tries to restore decorum in the courtroom.
I have 2 requests. One is that when I wish to speak, that you give me that courtesy. And when you wish to speak, I will do the same. As long as we continue to be discussing what is relevant to today's case.
There is no relevance to today's case because you don't have jurisdiction.
Not only does Marple argue the court lacks jurisdiction, but he also claims the state has no authority to police his driving in the first place.
Obviously, 382A 9-109 defines the automobile as consumer goods. Consumer goods do not have to be registered. Consumer goods do not have to have a, quote, license, unquote, in order to travel.
And speaking of driver's licenses, Marple doesn't believe in those either.
It's not a license. It is a photo ID that I purchased.
Still, Marple wants his back in his wallet.
I want my property back.
All right, well, that is.
I asked for it 4 times. You refused to give it to me.
Well,
That's conversion.
all right.
That is conversion. Criminal conversion.
And finally, the state representative lays it all on the line.
All right,
There's going to be a stop to it. Are you going to recuse yourself? I ask you that.
I am not going to recuse
You're not going to recuse yourself.
I do not believe there is any valid reason for me to recuse myself. I believe that I have been fair and impartial. I can continue to be fair and impartial. We are scheduled for a trial today, and I want to let you know that the trial is going to occur today. I would urge you to participate in the trial.
I'm not participating in something that cannot do. It is a total fraud.
The trial would proceed, but after he continues to disrupt the proceedings,
The principle is the people that I represent are being ripped off. That's what it's all about. And if you're going to continue with this, you will be paying the penalty, I assure you.
Judge Spath simply walks out of the courtroom. State Representative Dick Marple would ultimately receive a judgment of guilt through the mail and was ordered to pay a $310 fine for driving with a suspended license.